Welcome to our new video. Today we're going to discuss the most important CSR questions, Part 2, especially questions 11 to 20 that every business and entrepreneur must know about corporate social responsibility under the Companies Act 2013. If you're a CA aspirant, a business owner, or a compliance officer, you don't want to miss this. So let's dive right in. 11. Whether CSR expenditure of a company can be claimed as business expenditure? No, the amount spent by a company towards CSR cannot be claimed as business expenditure. According to Section 37(1) of the Income Tax Act, 1961, which was inserted through the Finance Act 2014, provides that any expenditure incurred by an assessee on the activities relating to CSR, referred to in Section 135 of the Companies Act, 2013 shall not be deemed to be an expenditure incurred by the assessee for the purposes of the business or profession. 12. What tax benefits can be availed under CSR? No specific tax exemptions have been extended to CSR expenditure. The Finance Act 2014 also clarifies that expenditure on CSR does not form part of business expenditure. 13. Whether contribution in kind can be monetized to be shown as CSR expenditure, the requirement comes from Section 135(5) that states that the board of every company shall ensure that it spends. Therefore, CSR contribution cannot be in kind and monetized. 14. What are the different modes of incurring CSR expenditure? CSR expenditure can be incurred in multiple modes. Activities route, which is a direct mode wherein a company undertakes the CSR projects or programs as per Schedule 7 of the Act, either by itself or by engaging implementing agencies as prescribed in companies' CSR Policy Rules 2014. Contribution to funds road, which allows the contributions to various funds as specified in Schedule 7 of the Act. Contribution to incubators and R&D projects, as specified in Item A, and contribution to institutes, organizations, engaged in research and development activity, as specified under Item B of Schedule 7 of the Act. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. 15. Can CSR funds be utilized to fund government schemes? The objective of CSR provisions is to involve the corporates as partners in the social development process. Use of corporate innovations and management skills in the delivery of public goods is at the core of CSR implementation by the companies. Therefore, CSR should not be interpreted as a source of financing the resource gaps in government schemes. However, the board of the eligible company may undertake similar activities independently, subject to fulfillment of companies' CSR Policy Rules 2014. 16. Whether involvement of employees of a company in their CSR projects can be monetized and accounted for under the head of CSR expenditure? No, involvement of employees in CSR projects of a company cannot be monetized. Contribution and involvement of employees in CSR activities of the company will no doubt generate interest, pride in CSR work and promote transformation from corporate social responsibility CSR as an obligation to socially responsible corporate SRC in all aspects of their functioning. Therefore, companies should be encouraged to involve their employees in CSR activities. 17. Which activities do not qualify as eligible CSR activity? Rule 2(1)(d) of the company's CSR Policy Rules 2014 defines CSR, and the following activities are specifically excluded from being considered as eligible CSR activity. Activities undertaken in pursuance of normal course of business of the company. However, exemption is provided for 3 financial years till FY 2022-23 to companies engaged in R&D activities for new vaccines, drugs, and medical devices in their normal course of business related to COVID-19. This exclusion is allowed only in case the companies are engaged in R&D in collaboration with organizations as mentioned in Item X of Schedule 7 and disclose the same in their board reports. Activities undertaken outside India, except for training of Indian sports personnel representing any state or union territory at national level or India at international level. Contribution of any amount, directly or indirectly, to any political party under Section 182 of the Act. activities benefiting employees of the company as defined in Section 2K of the Code on Wages, 2019. Sponsorship activities for deriving marketing benefits for product services. Activities for fulfilling statutory obligations under any law in force in India. 18. Whether the companies can undertake any CSR activity mentioned under Schedule 7 of the Act for the exclusive benefit of their employees, workers, and their family members. Rule 2.1 (div) of the company's CSR Policy Rules 2014 states that any activity benefiting employees of the company shall not be considered as eligible CSR activity. As per the rule, any activity designed exclusively for the benefit of employees shall be considered as an activity benefiting employees and will not qualify as permissible CSR expenditure. The spirit behind any CSR activity is to benefit the public at large, and the activity should be non-discriminatory to any class of beneficiaries. However, any activity which is not designed to benefit employees solely, but the public at large, and if the employees and their family members are incidental beneficiaries, such activity would not be considered as activity benefiting employees and will qualify as eligible CSR activity. 19. Are activities undertaken by companies outside India for the benefit of resident Indians permitted as eligible CSR activity? Rule 2D of the company's CSR Policy Rules 2014 clearly states that any activity undertaken by the company outside India shall not be an eligible CSR activity. The only exception is training of Indian sports personnel representing any state or union territory at national or international level. 20. How can companies with small CSR funds take up CSR activities in a project mode? A well-designed CSR project can be managed with small CSR funds as well. Further, there is a provision in the company's CSR Policy Rules 2014 that enables such companies to collaborate with other companies for undertaking CSR activities by way of pooling their CSR resources. Refer Rule 4.4 in Companies SR Policy Rules 2014. So that's it for today's video. We hope you learned something new and valuable about CSR FAQs under the Companies Act. If you've faced any CSR-related challenges or have any questions, do share your experience in the comments below. And of course, don't forget to like, share, and subscribe to our channel for more such informative content. Thanks for watching, and see you in the next video.